as to what is the freedom of conscience and what is page 149 of my note, the note just now we passed on. The second paradigm. Conscience is a term that relates to the philosophical approach of a man diverse from the idea of religion. While religion mainly bases its existence on the belief system of a man, conscience is the quality of mind which inquires into the beliefs and facts. While the belief system could be individualistic in nature, conscience relates to the philosophical approach of life, which would have universal application. Now, the reason why, my lord, I placed this for lordship's kind, there are other things about what is philosophy, etc. I would not answer it in simple terms. Freedom of conscience means if that voice which all of us hear, my lord, in the recesses of our heart, whether it is morning or night, whether we are outside, we are inside, wherever we are, that voice is always telling us something. And we all hear it loud and clear. We choose to close our ears if we don't want to hear something which is unpalatable to us. And we say, keep quiet. But that voice is not keeping quiet. It is going on telling you. So that is the right of freedom of conscience is what your heart tells you, what you think is the way forward. Now, if you take Hindu philosophy, even in Hindu philosophy, there are three main schools of thought, Advaita, Dvaita, and Vishishtadvaita. They are all Hindu only, but their philosophical thought is different. So, my lord, the constitution makers, when they did that, they wanted the freedom to be there to a person, to a citizen, to have his own thought process. You should not curtail that freedom of thought process. That is the conscience. And freedom of religion, I'll come to, Lord, what is religion? There are judgments on the point, Lord. The juxtaposition between religion and religious practices, cultural practices, and to what extent section 25 is subjected to section 19. Well laid out decisions that I'm allowed. I'll quickly take a lordship through a few of them with only the relevant portions. Now, my lord, in the next few paragraphs in my note, I have, my lord, set out in serial order. I don't propose to read it, just for a lordship's immediate reference, what I've just now submitted on the pleadings, my lord. That is all there. Now, my lord, in paragraph 8, I point out that public order, the expression used in article 25, I'm reading, my lord, paragraph number, referring to para 8 of my note at page 4. Public order, for the purpose of section 25(1), as his lordship, Lord Justice, Honorable Justice Dikshit has been repeatedly saying that the public order is an expression, my lord, which has to take color from the context in which it is there. In fact, the very famous author, Mr. Sirvai, my lord, refers to that. I've made a reference to that. I'll point out that also. So my submission is that the expression public order in section 25(1) may not mean the same thing as that expression in section 19(2). Now we are dealing, we are not deciding this expression public order in vacuum. We are deciding it in the context of an educational institution. Now, in an educational institution, if the institution, the body which has taken the decision, my lord, is a representative body, it is not some one person giving a dikkat and everybody agrees to that and just says no, like a veto power. Not like that. It's a democratic body. There are at least 7 or 8 responsible people. Parents, representatives are there. It's all decisions are unanimously taken. If they take a decision that for public order, for maintaining good relationships in the college, in the school, we must have a uniformity in the attire that everybody wears. That is public order. It doesn't mean, my lord, only when there is disorder, it is a breach of public order. I would respectfully say that when there is an attempt made to keep order, that is public order. It does not necessarily mean that order comes only from disorder. That's also not so. Then, my lord, kindly now turn to Annexure 1, my lord, in this compilation, which is at page 18. I may not rely on Mr. Sirvai's commentary at ink page 20. That I've given the title page, everything at page 18 on the interpretation of the Constitution, serial page 20, the first paragraph on top. About 4 or 5 lines from the top. The sentence begins with the word further. Further, a detailed constitution like ours is drafted as an instrument of government designed to secure the well-being of people. It is not designed to stimulate juristic and philosophical thought or to
stimulate historical research.
or to stimulate historical research in interpreting the Constitution. For any such design would mark a grave failure of precise and careful draftsmanship. The next sentence is very interesting. The draftsman must be credited with the elementary knowledge that his words would be understood in their ordinary sense, and that, as Justice Khanna felicitously put it, it has not yet been erected into a legal maxim of constitutional construction that words were meant to conceal thoughts. So aptly, Lord, the author has taken one sentence from Justice Khanna's words in Yashwananda Bharati case. The observations of Lord Simon in Black Clawson cited at para so-and-so of the text, that in essence, drafting, enactment, and interpretation are integral parts of the process of translating the volition of the electorate into rules which bind themselves, support the view expressed above. So, my lord, if we apply this principle of interpretation of the Constitution, my respectful submission, my lord, is that we have to interpret Section 25 standing alone, and we cannot import the same meaning to public order as one gave in Article 19.2. Then, my lord, one more submission that I'm making is that I'm fortified by authority, my lord. I have a child at home. The child is, say, 10 years old. The child is misbehaving. I tell the child, please don't misbehave. You're not supposed to do this. You're supposed to behave yourself. The child doesn't listen. It gets up into a fit and throws things at me and shouts at the parent. The parent, if he is very patient, will cajole the patient, will cajole the child for some time. If the child is still continuing, then the father or the mother will berate the child to say, either you behave yourself or you're going to get one slap on your face. They will only tell the child that. If till it continues and the patience runs out, then the child will get a slap also. Now, these are parental rights in the welfare of the child. It is not that the parent is punishing the child because the parent gets some satisfaction from it. It is to discipline the child, and that is important for the child. And that is the reason why the parent exercises that power. Now, my lord, the authority says that when you send a child to school, my lord, imagine the same scenario playing out, my lord, inside the classroom. Now, the child is doing something which he is not supposed to do. The teacher is in the classroom. The child goes on doing something which it is not supposed to do. Now, what will the teacher do? The teacher will tell the child, hey, you're not supposed to do this. See, all your friends are not doing it. Please follow. And very sweetly, very nicely, it will be told. If the child is defiant, then the next step is applied. And that is a matter of disciplining. So, my lord, when you send a child, because the parent is not there to discipline, if this happens at home, the parent will discipline. If it happens in school, then to that extent, my lord, authority says that you have delegated, the parent has delegated your parental responsibility to the teacher or the institution, and you send the child there, in loco parentis. Kindly, my lord, see, in paragraph 12, my lord, I have captured that idea. I'm sorry, paragraph 10, para 10, at page 4 of my submissions. The authority of an educational institution and teachers is to enforce discipline among students in common law in my submission note, my lord, page 4. The teachers, being in loco parentis, can exercise quasi-parental authority to enforce discipline. A parent, when he places his child with a teacher or a school, delegates to him all his own authority, so far as it is necessary for the welfare of the child. The master can therefore inflict a moderate chastisement on his pupil or apprentice. The modern view is that the schoolmaster has his own independent authority to act for the welfare of the child. This authority is not limited to offenses committed by the pupil upon the premises of the school, but may extend to acts done by such pupil while on the way to and from the school. Now, I've given the authority in Ratan Lal's book, my lord, at page 21 in the same compilation. Annexure 2, it is marked, my lord. This is under the heading of justification of torts, there, my lord, parental, quasi-parental authority. What I put in the note, my lord, your lordships will get in the second paragraph. So, the authority vests not only in what you do in the school, even while going to school, coming to school, you can do it. But in this present case, what the school has done, my lord, is that it says it is in the interests of everybody that no child will wear any headscarf or anything other than what is prescribed uniform. This is universal. Now, my lord, there are some very highly ultra-orthodox Brahmins are there, my lord. Those boys, even girls for that matter, they are, after the boys' Upanayam is done, if some category of boys come and say, no, that is our religion, I am going to practice that only, I will not wear any pant or shirt, I will come in that dress only to school. Then what will happen? Everybody can do whatever they want. And the justification is, there is a religious instruction for me to do that. Even if it is so, the authority of the school, my lord, is something which cannot be, I would say, my lord, belittled, because that is the school has to maintain the discipline inside the classroom. And in their authority, my lord, in their wisdom, if they've taken this decision, bona fide, not questioned for 16 or 17 years, 18 years, not questioned from 2004. Then, my lord, I go to another point. In paragraph 12, my lord, this college development authority, my lord, is only a body which is acting on behalf of the college. It is not some stranger. It is, the school is being run. There is a representative body that is looking after it. Much was argued about MLA being there, MLA not being there. Even if the MLA is not there, I can understand. If the MLA comes every meeting, he says, whatever I say, you have to write down minutes. Otherwise, I don't sign the minutes. Supposing he says, if such an allegation is made, I will have to answer it. But there's no such allegation, except saying you will have some political thinking and all. Not, I have political thinking, but not. If I am sitting on the board of directors of a company, my political thinking has no role there. I have to discharge my duty while I occupy the position. So if I go to the legislative assembly and I vote in a particular manner, speak in a particular manner, it doesn't mean that I'm sitting in the capacity of a parent's stage in a school. What will that have to do with this? It will not have. Even your lordships, my lord, sitting on the administrative side, my lord, your lordships take so many decisions. But when it comes to the judicial side, decisions are not made in the same manner. On the judicial side, decisions are made, my lord, taking note of what parties are placed before your lordships, hearing both sides and taking a view one way or the other. But it's not so, my lord, in administrative side. Same way, if MP or MLA is there, it makes no difference. And so this authority which is given to school is being exercised by this body. So all this entire argument about, oh, there's no statute, there's no legality, is that assume there is nothing, Lord. If there's a committee set up, it's a representative committee like this. And they have said that we'll have uniform for 20 years. It has been having. Everything was peaceful. Today, my lord, what has changed? Nothing has changed except for institutions like the CFI and other people who have come and instigated the children and their parents And as the result is that the entire field of education is suffering. Now, my lord, I go to the next point on what is this freedom of religion.
One question.
Yes, ma'am.
Where is the legal authorization to induct MLAs in the Act?
I would submit, my lord.
That question may not arise.
May not arise because that is not under challenge.
Please, my lord. There's no challenge to it.
Constitution is, of the committees is not under challenge before us.
Please.
Yes, and word, my lords, I appear for that committee, my lords. I will answer that, and your lordships are right. My authority to officiate in the committee has not been challenged, my lords, and I will make good that.
Then, my lord, in paragraph 12, I have made a submission that the opening words of Article 25, my lord, the Chief Justice has referred to it more than once, my lord, so I don't want to, my lord, dwell too much on it. The language is very clear. The language says subject to. And when the language reads in that fashion, what is the fundamental right? The fundamental right is subject to so many things. It's not an absolute right.
No individual right is absolute, as we understand.
Gratefully, I respectfully agree, my lord. All rights, my lord, in a democratic polity, my lord, in a republic, my right, it should. That's what the Honorable Supreme Court, my lord, has pointed out in 4 decisions. They relate to Hindus, Christians, Muslims. All of them, my lord, have been treated by Supreme Court in 4 different decisions at different points of time. Exactly, my lord, saying what your lordships, my lord, has just now said. They have laid down that my right of peaceful existence cannot be threatened by somebody else saying, I want to exercise my religious freedom. That's, my lord, seems to be the law. Then, my lord, in paragraph 13, I have, my lord, said about whether it is an essential practice or not. I'm not going to dwell on that, my lord, but just take your lordships, my lord, to 1 or 2 decisions. Annexure 3, my lord, in the case of church, there was a case of loudspeakers being used for propagation of some ideals. The judgment, my lord, is 2007 SCC 282. The citation is given there, my lord. Your lordships will find the judgment at page 23. I'll only read a few lines at page 29. At page 29, at Placitum, Lord B, they refer to an old Calcutta judgment. He relies upon the judgment of the Calcutta High Court in Birangana Religious Society versus State, wherein the court dealt with a similar matter. The question posed by the court for consideration were whether the public are a captive audience or listener when permission is given for using loudspeakers in public, and whether the person who is otherwise unwilling to bear the sound and or music or communication made by the loudspeakers is compelled to tolerate all these things against his will and health. Then, my lord, the quotation there, just after that at Placitum D, my lord, may kindly be seen. This is again an extract from the High Court judgment. It cannot be said that religious teachers or spiritual teachers who laid down these tenets had in any way desired the use of microphones as a means of performance of religion. Undoubtedly, one can practice and profess and propagate religion as guaranteed in Article 25(1) of the Constitution, but that is not an absolute right. The provision of Article 25 is subject to provisions of Article 19(1)(a) of the Constitution. On true and proper construction of the provisions of the Article 25 read with 19(1)(a), it cannot be said that a citizen should be coerced to hear anything which he does not like or which he does not require. Not one sentence in the next following page, page 31. They say, even if praying is permitted, Where is it that you should permit a loudspeaker? Class item F, my lord. Because as stated earlier, no religion prescribes or preaches that prayers are required to be performed through voice amplifiers or by beating of drums. In any case, if there is such a practice, it should not adversely affect the rights of others, including that of being not disturbed in their activities. So, my lord, if in the wisdom of this committee, they independently take a decision, and it is nobody's case that there was some coercion, anything like that, no challenge, that there should be uniformity maintained in classroom. And they feel that that is good for the students because it will rid the students of this overarching belief about religion, about this, about that, everything. They are come to learn education, so why should you want all these things? External symbols, not needed. Then, my lord, one more judgment is next judgment, my lord, at page 33. This also related to use of loudspeakers at page 76, my lord. Paragraph 150. Or may I just go straight, my lord, to 150? They talk of pluralistic country, etc., my lord. I would request your lordships to go to page 78, para 158. This was a case where the Hindus made a plea that bursting of crackers is part of our celebrating our festival, so you must permit it. And the court said no. The reasoning, my lord, is at page 150, page 78, para number 158. Another argument that has been put forward to remove the restriction during festivals is that they are celebrated by most of the people and that an inconvenience to a few should not become the reasons for restraining a greater lot. In P.A. Jacob was superintendent of police, it has been said, quote, however wide a right is, it cannot be as wide as to destroy similar or other rights in others. Jefferson said, no one has a natural right to commit aggression on the equal rights of another. And John Stuart Mill says on liberty, if all mankind minus one were of opinion, and if only one person was of contrary opinion, mankind would be no more justified in silencing that one person than he, if he had the power, would be justified in silencing mankind. And finally, my lord, they said no, it cannot be permitted. Then the last judgment, my lord, on this is Afzal's case. Your lordships will get it at page number 84. This is a case of judgment of the division bench of the Allahabad High Court leading to Azan. The question is formulated at page 87. The first paragraph on top of page 87, para number 12. From the facts mentioned above, the main questions that arise for adjudication are as follows. Whether any order prohibiting or restricting the recitation of Azan through sound amplifying devices is violative of Article 25 of the Constitution of India and therefore arbitrary and unconstitutional. And my lord, the discussion at page 90, 90, para 27. No person has a right to take away the right of others. There is no religious freedom in this country except the provisions of Article 25 of the Constitution, which is subject to public order, morality and health, and other provisions of Part 3, including 19(1)(a). Freedom of religion is subject to others' right as guaranteed in the 19(1)(a) of the Constitution. Namely, religious freedom cannot abridge or take away or suspend others' right under Article 19(1)(a) regarding freedom of speech and expression. Use of loudspeakers is not an integral part of the Azan or necessary for making Azan effective. Then if it affects others' fundamental rights, my lord, that can be restricted. I have also referred, my lord, to in paragraph 14 of my note at page 10, the right of a Sikh religious person to carry a kirpan. I've just given it, my lord, for completeness of the sake, because there is one explanation, my lord, to the constitution. In Article 20.
The explanation has been saved.
Yeah, your lordships have seen it there.
Constitution itself.
Yes.
Okay.
Then, my lord, section Article 25(2), my lord, I'm reading paragraph 15 of my note, just coming to the end now. Paragraph 15. There was a system, my lord, of abolition of sati, and also, my lord, a right to have more than one spouse among the Hindus. That was, my lord, the subject matter of some consideration by the Supreme Court. If your lordships could go to, my lord, page 102, the judgment of the Supreme Court in Khurshid Ahmad Khan's case. At page 105, the argument was that I have a right of polygamy. And at paragraph 13, my lord, the lordships refer to placitum, my lord, between F and G. This court also upheld the view, the lordship has it, my lord, at page 105. This court also upheld the view of the Allahabad High Court upholding such a conduct rule. It was observed that a practice did not acquire sanction of religion simply because it was permitted. Such a practice could be regulated by law without violating Article 25. The court observed, in so and so, the constitutional validity of the Bombay Prevention of Hindu Bigamous Marriage Act was challenged on the ground of violation of 14, 15, 25. A division bench consisting, Lord, of one of the two of the greatest judges our country has had, Chief Justice Chagla and Justice Gajendra Kadkar, held a sharp distinction must be drawn between religious faith and belief and religious practice. What the state protects is religious faith and belief. If religious practices run counter to public order, morality, or help of a policy of a social welfare upon which the state has embarked, then the religious practices must give way before the good of the people of the state as a whole. Then, my lord, they continue to quote from that judgment at page 445. This is a continuation of the quotation, my lord, of the judgment. At the numbered paragraph is 57. There's a quote. This is a continuation of the quotation, my lord. Fifth line in that, even if bigamy be regarded as an integral part of Hindu religion, Rule 27 of the government rules requiring permission of the government before contracting such marriage must be held to come under the provision protection of 25(2)(b) of the Constitution. So when there is the freedom is nothing, absolute freedom is there. Then Lord, kindly turn to the next page. There's a very interesting observation. From again, my lord, Mr. Siroy's book, page 109. The text is at 110. Lord, the court there was considering censorship in America and how his lordship, Lord Justice Douglas, makes a very pertinent observation there. May I read the para in the middle, page 110, middle paragraph. It begins like this, my lord. It will be seen. The lordship has not. page 110, right in the middle of that page. It will be seen that freedoms are conferred in absolute terms. That is, His Lordship is talking about American Constitution. And subject to fluctuating composition of the US Supreme Court, the trend has been to make a few exceptions to the freedom there granted as possible. For the freedoms there granted are the rule and restrictions of those freedoms, the exceptions involved by the court. In our constitution, that is US Constitution, the freedoms granted by fundamental rights are not absolute, as we have already seen. That is, the author is now talking about the Indian Constitution. Mr. Sirvai is referring to Justice Douglas, saying they are absolute there, and he is commenting now in India it is not so. In fact, Justice Douglas of the US Supreme Court in a celebrated case held that censorship of cinema films was constitutionally void, but he added, if we had a provision in our constitution for reasonable regulation of the press, such as India has included in hers, there would be room for argument that censorship in the interests of morality would be permissible. So, my lord, the US Supreme Court is saying, look at India's constitution. Such a regulation is necessary, and we would have loved to have it. But unfortunately, our constitution does not make a provision for it. So what can we do? We have no choice but to say that the censorship is absolute. And in that context, Lord, he appreciates
no benefit,
that India,
Mr. Naganand.
reasonable
Mr. Naganand, the US had no benefit of Dr. Ambedkar.
Yes, my lord.
We had.
Exactly. I respectfully bow down, my lord. And B.N. Rao and the great statesman, my lord, who drafted the constitution, because they had so much forethought that as society develops, how exactly the country should be governed. So, my lord, the freedom of the constitution, that is, in different countries, this, my lord, has had a checkered career. So, my lord, I will only request your lordship, my lord, to permit me to show annexure 9, that is page number 109. Your lordship has seen it, my lord. Yes. Then, my lord, I go to another subject on which, my lord, I request your lordship's kind permission to allow, my lord, my colleague and junior Raghavendra to argue that position. In a few minutes, he will do that, my lord. I will skip over portions. 116 to 1, page number, para 17 to 20, my lord, I will, with your lordship's leave, my lord, not deal with it, because they deal with the question, my lord, of international approach. What has been the approach in different countries? There are authorities for that, my lord. If your lordship permits, my lord, he will deal with it. I will now go to, my lord, para 21, Bijoy Emmanuel. Now, my lord, Bijoy Emmanuel, much argument has been addressed, my lord, on that judgment. The judgment proceeds, my lord, on the premise and assumption, and it was not disputed by anybody, that Jehovah's Witnesses, it's essential that they should not sing or praise anyone, any god other than Jehovah. That was essential tenet of the religion. That was taken for granted. Therefore, my lord, the court reached that conclusion to say that if you force him to sing, then it means that you are forcing him to act contrary to his religious faith, which is essential practice in his religion. Whereas now we are dealing with a situation, the learned Advocate General has pointed out, my lord, I don't want to repeat any of those arguments, that there are many countries, my lord, I remember, my lord, that in Iran, during the Shah's rule, before the Ayatollahs came in, the society was, Tehran was called the Paris of the East. It was, the life there was as flamboyant and as luxurious as it was in the most developed city of Paris in Western Europe. That is the policy which they followed. And there was no parda, it was a Muslim state. There's no doubt about it. The Shah of Iran was the head of the Ismailis and it was a Muslim state. But they did not believe in this. And therefore, he never enforced any of these things. And the women were completely free. I remember, Lord, in our college days, large number of young students, Lord, from Iran used to come to Bangalore because we had a good educational system here. They would come to join many famous colleges in Bangalore, then Lord, engineering colleges and other colleges. And we used to see hordes of them living here. Now, my submission is that at that point of time, it was felt this parda and these other restrictions were not needed in a Muslim state. Now, what should be the position in other developed countries, my Lord, is something which your Lordship may not hear from my colleague. My Lord, last submission, I've already drawn your Lordship's kind attention to this note on conscience. One other submission I'm concluding, my Lord. My Lord, this question has arisen. Now, in the case of, my Lord, two categories of Muslims, the Khojas and the Kachi Memons. My Lord, they traditionally, they said, though we are Mohammedans, certain principles of Hindu law will apply to us. I find one judgment, your Lordships will find that, my Lord, at page 155. A judgment, my Lord, of the Division Bench of the Bombay High Court in 1922. The reason why I'm citing this is only for this proposition, my Lord, that you may follow a particular religion, but the practices and customs of another religion can also get integrated into your religion. Now, my Lord, I was giving the example of tying Mangal Sutra in Kerala weddings. Now, among Christians, Mangal Sutra is not there, but Kerala it is there. That means they have assimilated it. Now, the same way, my Lord, in this case, at page 158, your Lordships will see a quotation is there from an earlier judgment. I'll just read one line there, my Lord. Page 158. The question arose there was, which part of the Hindu law principles will apply? Will the joint family principles, that is, son getting a birth right by birth in the family property, will that apply? Or only some other part of it will apply? And the court said only inheritance and succession will apply, not HUF property. In the middle of that court, in this state of authority, it appears to me not too much to say that it is now the settled law that except in matters of inheritance and succession. Your Lordship found it, no?
No, which page?
Quotation 158.
Page 158. Page 158. 158.
Ah.
In page 158, there's a quotation in the middle.
State.
I'm reading the middle of that quotation. In this state of authority, it appears to me not too much to say that it is now the settled law that except in matters of inheritance and succession, Kachi Memons are subject to Mohammedan law, and that upon the question of inheritance, the only way in which Hindu law affects their position is that it is to the law that one must look to decide who their heirs of the deceased Kachi Memon. So, my Lord, if I can just pause for one moment, what is the meaning, what is the effect of this is, entire Mohammedan law, which is based on Shariat and Quran, Holy Quran, lays down certain rules of succession for all Mohammedans. But now, by virtue of adoption of certain practices, courts have recognized now for more than 100 years that certain classes of Mohammedans, the traditional Mohammedan law doesn't apply to them. What applies to them is some portions of Hindu law would apply to Mohammedans also. It looks like incongruous, but it is so. Same thing, Lord, the native Christians in the province of Coorg under the Madras Presidency, they were excluded from the applicability of the Indian Succession Act of 1925 by a notification made. That means they were not governed by the law which governs Christians. They were continued to be governed by the law which governs Hindus. Now, does it mean that this is contrary to religious practice? This is well settled. And there are catena of decisions on the point. In this judgment also, my Lord, there's elaborate discussion. And the conclusion is at page 173. The second para, my lord, fourth line. There was a time, page 173, my lord. Second para, fourth line. There was a time when it was assumed that Hindu law of joint property applied to Kachi Memons. So, my lord, entire law was applicable. And they give the decision. Asha Bai versus Haji Taib and Muhammad Siddiq versus Haji Ahmad. But these decisions are now obsolete, and the application of Hindu law is now restricted to cases of succession and inheritance, as it would apply in the case of an intestate separated Hindu possessed of self-acquired property. So the law has developed, it has changed. Nobody complained. Now I remember, Lord, an interesting case, judgment of this honorable court also, Lord. One very famous gentleman from Bangalore belonged to this same community, Kachi Memons. He was a Mohammedan. His argument was, Wealth Tax Act is not applicable to me because I am governed by traditional Hindu law relating to joint family. Though I am a Mohammedan, an association of persons was not an SSC under the Wealth Tax Act. So his contention was, in fact, I had occasion to appear in the case both the tribunal and in the High Court, my lord. The argument was that no, I cannot be assessed because traditional Mohammedan law doesn't apply to me. Of course, my lord, that case had a checkered history and then there was some amendment. But I'm just mentioning that, my lord. So, my lord, in conclusion, my lord, I'm deeply obliged, my lord, for giving me more time than what I had sought from your lordship. I apologize if I've taken more time. The only submission I make, my lord, in conclusion is this, very respectfully, my lord. Let the drum beaters on the roads, my lord, not threaten the society. Lord, we are a harmonious society. In fact, my lord, in Udupi, I know for personal reasons, my lord, the pontiffs of the Udupi Ashtamathas, they were helped and supported by the Muslim brethren there. There are a large number of Muslims who live around the Krishna Mata. There is a car festival that is held. There are so many other festivals that are celebrated. They come, they participate, they help, they assist. They don't make any distinction. That has been the harmony, my lord, that has been maintained in society. Now, my lord, for some unknown reasons, people, my lord, who have no stake in this, ultimately, my lord, we must tell our children, don't make a distinction of any kind. Lord, if I can quote Bhagwan Baba, my lord, he always said that divine spark is there in everyone. You cannot make a distinction between his color, his religion, where he comes from, what his language is. It's the same divine spark that goes into everybody. So you treat everybody as your brother and sister. That's the only way in which society can be peaceful. Lord, this is a very simple issue. If children, my lord, come to school and don't wear these external symbols of religion. Now, my lord, see what has happened because of what this agitation. Now, one right-wing faction of the Hindus have now said that I want to buy a saffron scarf and I'm going to wear a saffron scarf to school. Then, my lord, tomorrow the Mohammedan boys will say, I have to wear a skull cap always. I'm going to wear a skull cap and come to school. Where is this going to end, my lord? Are we going to polarize the society like this, or are we going to bring about harmony? But my respectful submission is, there's nothing pernicious with what has been done. It is consistent with what has been the Sarva Dharma Samanvaya that has always been maintained. And my lord, your lordships may, my lord, be pleased to dismiss the petition, my very humble and respectful submission. Deeply obliged, my lord, for your kind patience.
Thank you.
Wait, please, your lordships. I beg to appear for respondent number 7 in the same writ petition. And with your lordship's kind leave, I'd like to cover one aspect that senior Mr. Naganand has left to me, which is the position in other jurisdictions as to the width of the freedom of religion and the approach of the European Court of Human Rights in the light of international conventions. I'll try to be very brief, my lords. All of it is covered in this very note of submissions. I'll request your lordships to please take the note of submissions. The lordships will be kind enough to come to page 12 and permit me to point out para 16 of the note. page 12 of the note, bottom of the page, is para 16. May I point that out, Mullets? Para 16. The width of freedom of religion differs from country to country depending on the constitutional provision in that regard. The First Amendment to the US Constitution and also Section 106 of the Commonwealth of Australia Act are almost similar in their language. Reference to Constitutional Law of India.
We'll go through this. We'll go.
Yes, my lord. I was only requesting your lordships to kindly permit me to read the first few lines. Learned Senior Counsel has read the latter portion of this paragraph. Kindly permit me to place that first portion, the sentence starting with again. Again, it is attractive at first blush to refer to American decisions on the First Amendment to the US Constitution.
We are totally on the constitutional issues.
That's right.
So so far as the width of the freedom of religion differs from country to country is concerned, you have already elaborated in your submissions.
That's right.
And that we will consider that.
That's right.
So right now that is not required.
The point that I was trying to make.
We are confined to the constitutional rights.
That's right. So therefore, Mullets, certain decisions, American decisions, have been relied upon by Learned Counsel for the petitioners. And the point that I was trying to submit is that American decisions have no place in our constitutional system. And that's exactly what Mr. Silva has brought out in this particular paragraph. And Mullets, as far as American and the Australian constitutions are concerned, because there the freedom of religion is virtually limitless and unrestricted. And it is the language of the constitutional provision is an injunction against the state. Congress shall make no law. And likewise in Australia, Commonwealth shall make no law, which will offend the freedom of religion. Whereas here we have Article 25(1) starts with a restrictive clause, which is subject to.
And 25(2).
And 25(2). 25(1)
gives the power to the state.
That's right, Mullets. I'm grateful. So, Mullets, the next point that I'd like to invite your lordship's kind attention to is page 14. Para 17, I needn't read because that is the provision of the Australian Constitution. And Mullets, para 18 is a very pertinent point in respect of the present dispute. Kindly permit me to place that. Para 18. As submitted above.
You said in Turkey the
secular country.
Which is a Muslim country. No, which is a secular country, but has a majority population of Muslim, wearing of hijab generally has been prohibited.
Please mark this, in a state-funded religious school. In a state-funded religious school, wearing of hijab has been, and that was right up to European Court of Human Rights, and that was tested on the anvil of Article 9 of the Convention, and the European Court of Human Rights has upheld the prohibition on wearing of hijab. And kindly see the last portion of that paragraph. When the girls attend classes in Quran, they may be permitted to wear hijab. Let's, in the present case, we are dealing with secular education, a public institution. Therefore, Mullets, in institutions imparting religious instructions, different considerations may apply. And Mullets, in para 19, I have dealt with position generally in Europe. And before that, Mullets, may I give your lordships only the relevant pages from that judgment in Kose. That judgment is annexure 11 to the writ petition, and that starts at page 129. A judgment that arose from Turkey, judgment of the European Court of Human Rights. Well, these judgments of the European Court of Human Rights are in French, and the translation is provided. So we produced the translation at 129, my lords.
Has been right from the day one saying that when Malaysian court judgment was referred, why at all we should travel that far? May not be, but anyway, this will throw some light which we will go through.
I am only placing this for this limited proposition, my lords, that even in a constitutional setup where the width of the freedom of religion is virtually unrestricted, prohibition on hijab has been upheld. More particularly in a state-funded religious school, in a country where the majority population is Muslim. That is the only citing this. If your lordships want, I will give the relevant pages. I will not read them. Page
all right, we don't need it. We will go through it.
That's right, my lords. The next thing that I wanted to point out to your lordship's kind consideration is Annexure 10, which is a comprehensive research article by two academicians on the approach of the European Court of Human Rights from various jurisdictions in Europe. Again, my lords, we are not relying on those cases as precedents here, but since your lordships are taking a holistic approach and interpreting our constitution, Ano Bhadra Kritavo Yantu Vishwataha, let noble thoughts come to us from all sides. That is the only purpose for which I am inviting your lordships' kind attention to this. And this, my lord, this article, which starts at page 111, has two parts. The first is religion in education. We are not concerned with that. Please go to page 120, second part of the article, display of religious symbols in educational institutions. At 121, your lordships will see how various jurisdictions have dealt with this issue and how ultimately on an international platform, the European Court of Human Rights has resolved the issue and upheld the actions of the respective states. Those are my respectful submissions, my lords. I'm grateful.
Thank you. Thank you. Yes.
Yeah, please, Melot. Melot, I seem to be the last batsman, Melot, on this side of the. So I'll be brief, Melot. I have made a brief written submission. My colleague, Melot, Mr. Sriraj Gowda or Vishwas, Melot, will ask consideration. Melot, I've truncated this written submission, Melot, only to those aspects that have not been covered because rest of it, Melot, my esteemed predecessors have taken your lordships through. My lords, may I, before your lordship looks at, my lords, a few pages of this written submission, I also, my lords, have a compilation of decisions which I have put, but I will not trouble your lordships to go otherwise. Lords, would your lordships give me the permission, my lords, to pitch this a little differently at my lords' threshold? I represent, my lords, respondents number 15 and 16. I'm, my lords, the chair and president of the College Development Committee and the vice president. First submission is I adopt everything that my esteemed predecessor, my senior Mr. Naganand has submitted in terms of the authority, etc. I'm not even getting into it. But one question fell from my lord, just my lords, in the early part of the that, and the one of the petitioners was that there is some large-scale outsourcing of this authority of the school to some political entity. And therefore, my lords, the question was brought up saying, why is an MLA sitting here? Lords, I must demystify. The circular of the government, which is issued, my lords, in 2014, which has not been challenged, and series of government orders which have not been challenged, did not outsource any educational function to a politician. What it did was it organized educational institutions which are funded by the state. And this, my lords, the responding institution here is a PU college for women, exclusively funded by the government. It is a government PU college, which is a composite institution with the high school and the college. A committee, therefore, was constituted to ensure imparting education and the well-being of that institution is looked at in tune with the local requirements rather than having one particular state-directed formula for the entire state. Therefore, my lords, a committee was constituted. The committee only is presided over by the MLA, and that MLA may or may not belong to the political dispensation which is in power during that time. For example, my lords, in itself, we have had MLAs who have chaired, my lords, the college development committee across political lines. It has not been, my lords, the bedrock of any one political party. And as Mr. Naganand rightly said, when an MLA sits here as the president, he does not sit here as, my lords, a member of any party. Number one. Number two, there are bylaws constituted by this committee itself, my lords, in terms of how the committee will function, and I have put that, my lords, as part of my statement of objection. Lords, kindly see, apart from the president, there is a vice president who is nominated, who is either the municipal president for the area or a local leader, my lords, of some standing who is nominated. Now, barring these, the other members are 4 members from the parent community, out of which there is representation to the SC/ST community, 1 person from an educational enterprise, 2 student representatives. If it is a co-ed education, 1 necessarily should be a girl. In this, both will be girls because we are a girls' institution. The vice principal of the college, a senior lecturer of the college, and if we are a composite institution with the high school, a senior teacher of the high school, and the member secretary for this committee will be the principal of the college. Therefore, my lords, this institution has not been challenged, and a question came up. My lords pointed out saying, how is this MLA there? I am not there because, my lords, I am the MLA. I am there because the local requirements of what the institution should or should not have in terms of governance is taken care of by a committee that has plurality within it. Number one. Number two, Millis, there are, I will not trouble your lordships with series of wild allegations of defendant numbers 15 and 16, saying that they are sitting there without authority and therefore a quo warranto must be issued in the absence of challenging any one of these circulars and guidelines. Therefore, I will let it be, I will not distract that.
But whether this relief of quo warranto can be granted?
How can it be? It seems to be that an overnight attempt at drafting a petition, and with utmost respect, a petition consists of rhetoric more than, my lords, pleading for your lordships. My lords, in that light, when I pitch, my lords, my submission before your lordships a little different. A case was made out of 1A rights before your lordships. A case was attempted to be made up of a 25 right before your lordships. And a case was also attempted to be made out of privacy of the individual before your lordships. Now, on all of these aspects, there have been answers that the respondents have been brought in. But my lords, my submission is the following. When your lordships get 25.2, and I will pointedly come to that exercise of whether 25.2 can trounce 25.1, but keeping that aside for a minute, when your lordships considers the rights enshrined under 25 and the rights enshrined under 19, 2 differences must be drawn out. A right to actually wear a particular attire in general connotation may be a right which will be culled out under Article 19(1) itself as an expression. A right to wear a religious attire or a particular religious symbol on a human body is a right which is amenable to Article 25 and not 19(1)(a), and that, my lords, has been laid down by Puttaswamy. I will read that paragraph of Puttaswamy. Therefore, a manifest of a religious understanding of an individual in the form of an attire of an individual is not a 19(1)(a) right at all. It is actually a 25 right. And, my lords, 25(2) can bring in, of course, with all the proportionalities, my lords, as the Constitution will impose, bring in restrictions on the manifestation of that right. Lords, that should be looked at in the light of 2 articles Of course, my lords, Article 51A has been read to your lordships, but kindly, my lords, permit me to point this out and please make a note, my lords. 51A, subclause E, subclause H, and subclause J. I will very quickly read it and juxtapose it, my lords, to 39F.
Duties.
My lords, please, 51E. To promote harmony and the spirit of common brotherhood amongst all people of India, transcending religious, linguistic, and regional or sectional diversities, and to renounce practices derogatory to the dignity of women. H. To develop scientific temperament, humanism, and the spirit of inquiry and reform. I am a school. J. To strive towards excellence in all spheres of individual and collective activity, so that the nation constantly raises to higher levels of endeavor and achievement. My lords, please juxtapose 39F for 1 minute. My lords, 39, interestingly, was brought in by the 42nd Amendment. The very amendment amplified the word secularism in our preamble, although it always that amplification occurred. Now, kindly see what that 42nd Amendment does in 39F. The state shall in particular policy towards securing that children are given opportunities and facilities to develop in a healthy manner and in absence of freedom and dignity, and that childhood and youth are protected against exploitation, against moral and material abandonment. Kindly, my lords, see the manner in conditions of freedom and dignity. My lords, I hope I am audible. It is not information that there is some echo, my lords. I will be a little slow. My lords, in this slide, the proposition that I am placing for your lordship here is the following. Generally speaking, a manifestation of an individual's belief in a particular religion under 25(1). 25(1), rightly so, my lords, uses the freedom of conscience, and that is, my lords, I read that 25(1), subject to public order, morality, and to other provisions of this part, all persons are equally entitled to the freedom of conscience and the right to profess, practice, and propagate religion. My lords, this distinction of freedom of conscience and professing, practicing, and propagating religion, my lords, is no more recent. Honorable Supreme Court, my lords, has two decisions, my lords, culled this difference. I will read those two paragraphs. But, my lords, may I wordsmith it differently? The freedom of conscience, my lords, is forum internum. For a person to, my lords, consciously decide whether he or she should follow a particular religion, should not follow a particular religion, be an agnostic, be a theist, be an atheist, no problem. That is, my lords, the freedom of conscience. That freedom, my lords, is absolute. The state cannot, my lords, in the process of its secular activity, dictate to an individual what he or she must decide conscientiously. However, practice, propagate religion is, my lords, forum externum. Once I have consciously decided that I will adopt a particular faith, how I manifest that faith in terms of my practice or in terms of professing it or propagating it to the world at large is forum externum. That forum externum is qualified under 25(2). And there is no doubt the Constitution after, my lords, the rendition in Sabarimala, etc. And I will come to that. Therefore, my lords, under 25(2), there is nothing which prevents the state to bring in, my lords, restrictions on the economic, financial, political, or other secular activities. Kindly note that, I am at 25. Nothing in this article shall affect the operation of the existing law or prevent the state from making any other law regulating or restricting any economic, financial, political. Please ignore economic, financial, political for a minute. Or other secular activities of the state which may be associated with religious practice. My lords, I now take an example. I am a practitioner. I have consciously decided, my lords, to adopt the Islamic faith, and I am, my lords, practicing that faith. The right for me to be a Muslim, the state cannot ask me why. That is an absolute right. However, in the manifestation of that, if I turn up and say I have to therefore wear a particular attire to school, to college, to court, as a practicing Hindu, if I were to insist on wearing a particular attire, because my community believes that that is the attire and intrinsic to my practice, to court or to my school, the question is that religious activity or is it a religious activity predominantly intruding into a secular activity? Education, my lords, in this country, and particularly education which is being imparted as public instructions with the aid or financial support, is purely, my lords, a secular activity. Article 28(1), my lords, clearly mandates that when it comes to, my lords, a secular activity of the state, religion will have no place. Kindly see, my lords, 28. Freedom has to at religious institutions or religious worship in certain education institutions. I read this, my lords, very slowly. No religious instruction shall be provided in any educational institutions wholly maintained out of the state funds. My lords, please ignore the etc., etc. Now, the question I ask myself, my lords, is a signature to 28(1). If the state, an educational institution such as the Girls PU College here, cannot impart any religious education at all, that has been read also to mean that there can be no religious manifestations in that institution. In other words, no citizen who is, my lords, getting public instructions in the state can insist that he or she will wear and necessarily has to wear a religious attire to that institution, even assuming they build a case on essential religious practice. With utmost respect, my lords, the petitioners have miserably failed in maintaining a pedestal of religious practice with the hijab. In para 54, my lords, of Shaira Banu, Lordship Nariman, my lords, calls out how that religious practice should be determined by the court. I will come to that completely. Now, even arguendo, it is an essential religious practice. It necessarily will have to yield in an educational institutions within the precincts of an educational institution. Therefore, a child may wear hijab based on the parents indicating the child outside of the institution. But when they attend public instructions in the institution, my lords, two reasons: profession, brotherhood, and secular education being imparted in the institution is paramount, and it cannot be trounced by religious symbols being indicated. My lords, your lordships, Justice and my lord Justice Dikshit also, my lords, indicated when there was Turkey decisions, etc., brought in, and an answer given by the petitioner is we are positive secularism. There it may be negative secularism. Positive secularism, my lords, unfortunately has been misread and misquoted by the petitioners. Positive secularism, as my lords brought down in S.R. Bommai, and I will read 3 paragraphs of it, clearly indicates that the state should do everything within its power to eradicate from the field of a public instruction, for example, or a secular activity, for example, any interference with religion at all. In that light, my lords, let me make this submission. We are looking at, my lords, building an institution in the state which is, my lords, of secular character. We have a law, unlike Vijay Emmanuel. Your lordships asked what is the ratio in Vijay Emmanuel. I'll come to that. Unlike the case of Vijay Emmanuel, where there was no law requiring a particular activity to be done, and therefore it was not that the law was imposing certain restrictions on an Article 19 right, or a 21 right, or a 25 right. Therefore, my lords, the Honorable Supreme Court, the ratio of Vijay Emmanuel is law. Not that somebody can stand and not sing. That is not the ratio. The ratio of Vijay Emmanuel, unless you have a law, there cannot be any restrictions imposed on a fundamental right. It can only be by a law. And their lordships found in Vijay Emmanuel that there was a circular which was issued, but that circular did not have the backing of the law. And therefore, they held asking them to do certain things. So long as they are respectfully standing, they need not sing. Vijay Emmanuel is not a manifestation of a legal authority to say that because I have an Article 25 right, the state cannot do anything about it, because my essential religious practice is that I will not sing in favor of anybody else other than my own God. The state can do nothing. The state cannot bring law in the broadest terms to impose certain discipline in a particular institution. Not at all. Therefore, please ignore Vijay Emmanuel from the reckoning and the discourse, my lords, for the purposes of determining this matter. In the present matter, Karnataka Education Act of 1983. The preamble to the Karnataka Education of Act of 1983 clearly indicates this, And please permit me to read 2 lines of that preamble, my lords. I will not trouble your lordship to look at the act, but I will read it. My lords, I am reading 2 lines of the preamble. For improving standards, better organization of discipline and control of educational institutions in the state, with the view to fostering the harmonious development of mental and physical faculties of students and cultivating a scientific and secular outlook through education.
This was pointed out by learned Advocate General.
Please, my lords. Now, when I say
Yes.
secular outlook through education, my lords, then the situation is the institution in the present case has every legitimate aim to ensure that within the precincts of a school, secular outlook is maintained to the core. Different communities are not distinguished by the attire they wear or the appearances they keep. My lords, the world is moving towards a uniform, not just in terms of a color, etc. A uniform, my lords, which is gender neutral. We are reaching a stage where we say, why should our girls wear skirts and our boys wear trousers? Why are we even making that distinction between our sons and daughters? That our sons and daughters must have education which empowers our daughters to believe that they are no less than from our sons. And therefore, they must have gender neutral uniform. Schools in Kerala, my lords, have brought in gender neutral uniform. That everybody will wear trousers. There will be no skirts for girls and trousers for boys. But here is a case where out of the 900 and odd children that are studying in my school, my lords, between, and my lords, for a minute, and I have pleaded this in my affidavit, I will, my lords, mention this. I have 956 children, my lords, in the school. Between PUC, about 600, and high school, about 350, 340. Out of these 956 children, 100 children are, my lords, belonging to the Muslim faith. Others, my lords, belong to the other faiths. Out of these 100 Muslim children, my lords, nobody till December, my lords, ever insisted on wearing hijab into school. 5 children, my lords, December, your lordships have seen the sequence of events, insist that now I will wear a hijab. 3 questions emanate. 1. Should the school therefore say under 25 you have a right to wear a hijab and therefore I will let you? Even assuming there is a 25 right, I will demonstrate there is no such right. Answer, my lords, is no, because school will ensure that I have cohesiveness and uniformity in my uniform. If anybody does not like that uniform, they are free, my lords, to find other institutions. This Udupi district alone, as an constituency, has 12 government colleges, not one. And it has multiple of a child can choose to go to an institution in which there is no uniform requirement in terms of not wearing a hijab or not wearing a saffron shawl. It applies to equal force, my lords, to a Hindu or a Muslim child. I don't want to, my lords, point to a particular community. My lords, in that light, I maintain cohesiveness and, my lords, ensure that there is secular outlook. Number 2, my lords, I will read decisions, my lords, from comparative law to place before your lordships. It is also the duty of a school. My lords, most of these children are minors. 8th, 9th, 10th standard minors, 11th and 12th standard, which otherwise in CBSE would have been a school, but in the state, my lords, it becomes a composite college in terms of a pre-university college. Most of them are minors. Therefore, my lords, the decision after they become majors to decide whether they will or will not profess a particular religion with vigor is left to them. But when they are minors, I have an obligation as a school to ensure that I provide the best benchmark to every girl child studying in my school, so that she is not shackled by a particular restriction that is imposed upon her or a demarcation that is made upon her to say, you necessarily will wear hijab. And that is a duty as a school, because I have to, my lords, organize my school on secular lines and ensure, my lords, that I achieve this secularism enshrined in the constitution through the mode of education. Therefore, the mandate saying cultivate scientific and secular outlook to education. My lords, in this light, please permit me to come to my note and read 4 paragraphs of S.R. Bommai. This question came up for consideration from S.R. Bommai on, can the state actually simply stand back and say Article 25? Where is my note?
Whether this institution is all girls school or co-education is there?
My lord, my lords, I am a all girls PU college,
All
a
girls.
government funded pre-university college, which is composite between high school and pre-university, with all girls students. There was no problem whatsoever. Children believed and professed various faiths, but until they came to school, they my lords wore whatever attire. But when they came into school, the precincts, the premises of the school, those attires, my lords, were removed, and within the school, everybody was in uniform. I will, my lords, place I have put photographs of all my public functions. In my statement of objection, I will request the court officer, just, my lords, optically prove to you. I will request the court of.
We just want to know one thing, whether all these petitions which have been filed, all the petitioners, whether they are students of purely girls' schools or the schools in which both boys and girls study.
My lords, in the petition appearing 2146, I can say, my lords, as a matter of fact, that it is an all-girls college, and all of them are students, my lords, in an all-girls institution, and all of them, my lord, did not insist on hijab till December, when this, my lord, so-called dispute erupted. For the last 2 years, no questions asked by any one of these children.
All right, the petitioners will reply to this, whether they all are.
School, my lord, in a
In that light, may I, my lords, straight away request your lordships to come to, my lords, my note, and I will be brief, my lords, in reading just a few paragraphs of that note. My lords, I have bifurcated it. My title A, my lords, is on secularism. Please come to straight away to page 2, my lords. I will not trouble your lordships with the rest of it. My lords, in Bombay, my lords, a 9-judge bench, this question came up in terms of, my lords, the issue of religious practices and secularism in the light of secularism being a basic structure. Please see, my lords, in page number 2, at the lower part, I am quoting 2 paragraphs from, my lords, Justice Ramaswamy's opinion. Please permit me, my lords, to come to 178 in particular, at the bottom quadrant of the page. My lords, I have quoted parts of the paragraph, my lords, and therefore I have been truthful to, my lords, wherever I have quoted extracts. And therefore, my lords, statements are indicated. The democratic society realizes the folly of the vigor of religious practice and strong religious consciousness not only narrows the vision, but hampers the rule of law. Matters which are are left personal to the individual, and the secular part is taken charge by the state on grounds of public interest, order, and general welfare. Lords, please ignore the lines. Please come to, my lords, the portion where your lordships will find the word government full stop. Further, there can be no democracy if anti-secular forces are allowed to work in dividing followers of different religious faith, flying at each other's throat. The secular government should negate the attempt and bring order in society. Religion, in the positive sense, is an active instrument to allow the citizen full development of his person, not merely in the physical and material, but in the non-material and non-secular life. Now let's please come to 186. The Constitution therefore protects only the essential and integral practices of a religion. The religious practice is subject to the control of public order, morality, and health, which includes economic, financial, or other secular activities. I stop there, minutes. Imparting education through public instruction is a secular activity of the state. None of the petitioners here can say that they are attending a PU college, either studying commerce, or humanities, or science. It is not secular education. Therefore, my lords, the interplay between religion and that secular education should be kept to the minimum, and concept of religion on it should be negated. My lords, please come to 180 part, my lords. The last 4 lines, I am reading only the relevant portions, the last 4 lines in 186. After the word worship, question mark, ... I quote, in order to secure constitutional protection, the religious practices should not only be essential part, but should also be an integral part of the proponent's religion, but subject to state control. Otherwise, only secular practices, which are not essential or integral part of a religion, are apt to be quoted as religious forms and can make the claim of being treated as religious practices. My lords, please ignore the reference. Towards the second half of the page, your lordships will find, my lords, I have quoted para 304 from his lordship Justice Jeevan Reddy's opinion, my lords, where he spoke for himself and for Justice Agarwal as he then was. Please permit me to read, my lords, in 304 over to page 5. My lords, I will read only about 4 lines from top. My lords, your lordships will find a sentence, my lords, about 5 lines from top. A sentence starting, my lords, how are constitutional? I'm reading that. How are the constitutional, social justice, liberty, and belief of faith and worship, and the equality of status and opportunity to be attained unless the state eschews the religion, faith, or belief of a person from its consideration altogether while dealing with him, his rights, and his duties and his entitlement. Secularism is thus more than a passive attitude of religious tolerance. It is a positive concept of equal treatment of all religions. Therefore, my lords, the equality in terms of uniform doesn't matter if you are a Hindu, within Hindu, whether you are a Kodava, Brahmin, Bant, or whether Christian, you are Orthodox, Jacobite, Syrian Christian, or within Muslims, you are Sunni or Shia. Everybody has the same uniform. My lords, kindly see 3 immediately after that, my lords. In short, in the affairs of the state, which includes imparting education, in its widest connotation, religion is irrelevant. It is strictly a personal affair. Therefore, when I prescribe as an institution, religion for me is irrelevant. And I am entitled to do so because of Article 25.2. Now, let's for 25.2, kindly see, we have a principal act, which is, my lords, a plenary legislation 83. We have Rule 11, my lords, which are made, my lords, as subordinate legislation under the 1983 Act. Rule 11 empowers every institution to have its own uniform. I ask my question why? Rightly so, because the state can't have one uniform across the state. Region specific, my lords, nuances require different uniforms for different regions. And therefore, my lords, power to impose a uniform in the academic rigors of a school, my lords, is made out by law. Nobody challenges that. But the challenge is actually having a law, which is a law, my lords, under 25.2, and I'll come to public order. You are eschewing or you are imposing restrictions on my right under 25.1. My lords, again on public order, after Sabrimala, that issue is no more essential. His Lordship Nariman, my lords, in the opinion in Sabrimala indicates that public order includes tranquility. My lords, maintaining cohesiveness in school is a matter of tranquility. Maintaining cohesiveness in, my lords, the community is a matter of tranquility. Therefore, my lords, imposing a uniform in school essentially ensures that secular education is imparted in the most peaceful and uniform manner. That is public order. If that is not public order, nothing else can be public order. Therefore, to indicate and say, no, this power is not public order. Law and order is a very small subset of public order. My lords, the last submission on before I move on. My lords, is paragraph 0 at page 5. I'm quoting 310 some aspects. The Constitution does not recognize, it does not permit mixing of religion and state power. Both must be kept apart, and that is the constitutional injunction. I could not have my lords provided for secular education, teaching physics, geography, and chemistry, and then indicating that everybody come in your religious attire, you're free to do so. That would erode into, my lords, the concept of secularism. So what is the petitioner asking for? Saying that please allow all religious dresses to be brought into school. It is no more secular education. My lords, secular education is not just academic discipline. Schooling is not just about academia. Schooling is about overall development of a child. And therefore, my lords, in that light, I will, my lords, go forward on the note. I'm conscious, my lords, that being the last, I have, my lords, restrictions in terms of time. My lords, please see paragraph 2. I am raising this 2026 SCC 899 Sheikh Mohammed Rafiq, my lords, only as an incidental matter. My lords, a question came up before the Honorable Supreme Court as late as 2020, where after TMA PI, etc., whether a minority educational institution will have complete freedom in terms of what they will do. The question was, and that if a minority institution which otherwise imparts religious education also as one or two subjects imparts general education such as arithmetic and English, when it comes to imparting that secular aspect within the religious institution, should they actually follow the master of the constitution in terms of recruiting a particular teacher, in terms of merit, etc., or is it free actually to bring in another religious scholar? The Honorable Supreme Court held no. Even if you are a religious institution, you are given the protection of TMFI, etc. In the small aspects of secular activity, even within that religious institution, you will actually maintain and bring in equality. Well, as I go forward from there. Well, I have on point B, my lords, I will not dilate. I have, my lords, already pointed out the provisions of the Constitution and, my lords, the preamble of the Act. My lords, I come to C. I am conscious that your lordships are not looking at comparative law from other jurisdictions, but I must dilate only one aspect in less than 2 minutes, and then I will go forward. My lords, I will not read the entirety of C to your lordships, but except to bring about one comparative analysis of what our Article 25 is and what Article 9 of the European Convention is. Please see, my lords, in page 8, at the footnote at the bottom of page 8. I have extracted Article 9. I'm just reading that, and I will say what happened in this case. My lords, Article 9 of the European Convention in 9.1 and 9.2 has all of this. It has the freedom of conscience included. It has the freedom, my lords, to profess religion, observe religion, and manifest religion, which is included. I read that, my lords. Everyone has the right of freedom of thought, conscience, and religion. This right includes the freedom to change his religion or belief, and the freedom either alone or in community with others, and in public or private, to manifest his religion or belief to worship, teaching, and practices and observance. Therefore, forum externum right, as we have in Article 25, is in 9. Kindly see, my lords, 2. Freedom to manifest one's religion or belief shall be subject only to such limitations as are prescribed by law and are necessary in a democratic society. I will come to that test of necessary in a democratic society as to what Supreme Court says, my lords. In the interest of public safety and for protection of public order, health and morals, or for the protection of the rights and freedom of others. My lords, effectively, Article 25.1 and Article 25.2 is Article 9, my lords, of the European Convention of Human Rights. My lords, in this light, would your lords, I seek my lord's indulgence, would your lordships permit me, my lords, to read paragraph 10, 4 paragraphs that I have quoted. They are very instructive, my lords, and I can't wordsmith it better. My lords, para 10 of my note at page 8. This is, my lords, the case of versus Turkey. A lot of Turkish decision, South African decision, everything is brought before your lordships. Okay, this happened and the other. Nobody looks at what is the analysis that the court did. My lords, in Laila Singh, the question was, even in a higher education, a student wanted to wear a hijab. Turkey, my lords, although a Muslim majority country, is a secular democratic polity, and therefore, my lords, there was a restriction on wearing hijab even to a higher educational institution where a child is a major, child is no more a minor. In that case, my lords, the question came up, and I read, my lords, para 10 of my note. I am reading, my lords, from internal pay, para 30. Please permit me very quickly to read these 4 paragraphs, and I will go forward. In their judgment, the constitutional judges explained firstly that secularism had acquired constitutional status by reason of historical experience of the country and the particularities of Islam compared to other religions. Secularism was an essential condition of democracy and acted as a guarantor of freedom of religion and equality before the law. It also prevented the state from showing the preference for a religion or belief. Consequently, a secular state could not invoke religious conviction when performing its legislative function. Stressing its involuntary nature, the Constitutional Court observed that freedom of religion, conscience, and worship, which could not be likened to a right to wear any particular religious attire, governed first and foremost the liberty to decide whether or not to follow a religion. Article 25, the freedom of conscience, is the right to follow a religion. It is not a right to manifest it by wearing a particular attire. I'll go forward, Millet, to explain that. Once outside the private sphere of individual conscience, freedom to manifest one's religion could be restricted on public order grounds to defend the principle of secularism. Everyone was free to dress how he or she wished, as a social and religious value and traditions of a society also had to be respected. However, when a particular dress code was imposed on an individual by reference to a religion, the religion concerned was perceived and presented as a set of values that were incompatible with those of contemporary society. In addition, in Turkey, where the majority of the population are Muslims, presenting the wearing of an Islamic headscarf as a mandatory religious duty would result in discrimination between practicing Muslims, non-practicing Muslims, and non-believers on the ground of dress, with anyone who refused to wear the headscarf undoubtedly being regarded as opposed to the religion or as irregular or as irreligious. My lords, I stop here for a minute. I have 100 Muslim children, my lords, in my school. 8 of them have my lordship saying, I want to wear a hijab. If I were to truncate my uniform and say that, all right, you wear a hijab, the remaining 95 Muslim children are now what, my lords, led to say what? That they are irreligious. And the only girls who are wearing hijab are therefore religious. This is independent of the even assuming it is not an essential religious practice. If an institution were to allow, let us say, any religious symbol, those people who don't carry the religious symbol are considered irreligious within the community. Then where is cohesion, my lords? Where is public order, my lords? Bringing in discipline and cohesion in school is the first step towards public order in society. My lords, I go
to that extent, Mr. Povaiya, to that extent, you sail with the learned advocate general.
Absolutely, my lords. It is, in fact, my lords, my primary duty as a school to mention, and irrespective of what the state does, state may or may not prescribe a uniform. It is my primary duty to make sure, my lords, that I have a uniform which will rid itself of all religious attire. And therefore, my lords, the wording of Ramaswamy Justice in, my lords, the first paragraph, that the state should actually, my lords, effectively ensure that religion is forcefully kept out of a secular discourse. I need to do the positive, not just tolerate it. My lords, I go forward. Please permit me to read, my lords, the last paragraph in para 9, page 9. A constitutional code that a student had to be able to work and pursue their education together in a calm, tolerant, and mutually supportive atmosphere without being deflected from that goal by signs of religious affiliation. It found that irrespective of whether the Islamic headscarf was a precept of Islam, granting legal recognition to a religious symbol of the type in higher education institution was not compatible with the principle that state education must be neutral, as it would be liable to generate conflicts between students with differing religious convictions and beliefs. That is, my lords, Article 21 of our Constitution. When we say no religion, my lords, teaching the Quran or the Vedas or the Bible, that is, my lords, a very simplistic way of looking at 28.1. 28.1 also necessarily then mandates that the state eschews all religious affiliations, my lords, or religious manifestations in an educational institution which imparts secular education. My lords, I now with this come to my lord, the test of necessary in a democracy. Kindly turn, my lords, this necessary in a democracy, my lords, is an indication as to seeing whether I need to control religious manifestation, not the freedom of conscience. Anybody can practice any religion. But should I control the manifestation of religion or manifestation of religious symbols or attire when it comes to secular activities in life? My lords, a lady or a man can wear a religious attire when he goes to pray or she goes to pray. No problem about it. They can wear the religious attire when they are performing religious functions. No problem about it. As Mr. Naganan rightly said, when a puja is going on, my lords, they will actually not have a cloth which is stitched. They will have an angabastram. But when that same gentleman or lady comes into the domain of a secular activity, whether it is education, whether it is practicing in a court of law, whether it is going to an office, whether private or publicly governed, that secular activity, they can't bring their religious manifestations to bear. And that is, my lords, what Sabrimala says as well, my lords. And I will read those 3 paragraphs in Sabrimala towards the end, my lords. Now, in this light, my lords, what is the doctrine of necessity in a democratic society? My lords, please read the 4th section. No, there's some.
All right, all right. So,
I think. I'm sorry, my lord. Your lordship.
oh no,
We are hearing you.
You are audible. There's no difficulty.
My lords, I want to be. The 4th section of the European Court of Human Rights, that is, my lords, in violation, applied the question necessary whether there was a violation of Article 9. The court must consider the applicant under Article 9 was interfered with, and if so, such interference is prescribed by law, pursuant to and was necessary in a democratic society within the meaning of Article 9. My lord, this necessary in a democratic society is not a concept to our view. My lords, please consider in Putta's judgment, but this issue of necessary in a democratic society was, my lord, brought in, and I read the paragraph. The Supreme Court 2009 CH-1 has adopted a similar test when adjudicating upon actions alleged to be in violations of the right to privacy, that is the right to permanent property of the Constitution. My lords, in paragraph Justice Palameshwar says so. As noted, whenever a state on the ground that it violates the right to privacy, the action of the on the following paragraph: A. Must be sanctioned. B. Action must be necessary for a legitimate and extent of interference proportional. My lord, this necessary in democratic society, I will end dovetails Act, which says scientific and secular output will be incorporated to education. Therefore, my lord, necessity in a democratic society mandate is that it is necessary to maintain the secular character of all public institutions. My lords, I go. My lords, please paragraph 87, 99. The Turkey. And my lords, I will go to essential. My lords, please. Paragraph 13, internal paragraph. 97. In a democracy in which several elements coexist in one and the same population, it may be necessary to take restrictions on freedom to manifest one's religion or belief in order to reconcile the interests of various groups and to ensure that everyone is respected. Now, 90. Please permit me to in Karnataka and Dalab, I go forward. Institutions found that in a democratic society, the state was entitled to the wearing of an equipment. If it was pursued protecting the rights of public order and public safety. In Dalab, in which an applicant is in charge of a small children, it stressed among other matters the impact that the symbol conveyed by her wearing could have whether it could have some of proselytizing others, seeing that it turned to be imposed on women by a pressing showdown in the Quran, it was hard to reconcile with the principle of gender equality. Well, it's with your systems with the hope that I'll be better at it in 1 minute. Exactly 1 second. Well, it's possibly I this may be better, man. Well, I go for like that the principle is undoubtedly one of the fundamental principles of society, which are in harmony with the rule of law and respect for human rights. In that context, particular universities may regulate the manifestation of the rights and symbols of the said society by imposing restrictions as to the place and manner of such manifestation with the aim of ensuring coexistence with students of various and thus protecting public. It all doubted. Malots, with this decision away, and Malots, I am going forward. I have Malots indicated in the next page, Malots, I have indicated rule 11, Malots. I will not touch upon rule 11. May I, Malots, another aspect. That is, at para. This is a question. Your lordships. Reconcile the and my lords reconcile to practice and profess my lords religion. My lords, in that one paragraph, my lords, I read. This is my lords in European, the Court of Justice of the European Union. I'm just reading that paragraph just to complete this, my lords. I will not read the recitation. Recently, the Court of Union in Webb and Mueller handled in 2021 July dealt with the question on whether an internal rule of a private undertaking prohibiting workers from wearing any visible sign of political, philosophical, or religious belief in the workplace constitutes to the workers who observe certain clothing rules based on religious custom a direct or indirect discrimination on the ground of religion or belief. It also referred to the concept of forum internum, that is the fact of having a belief, and forum externum, that is the manifestation of religious belief in public. Malots, I will not read its entirety, but 52 Malots kindly sees about 4 or 5 lines down, Malots. After the meaning of Article 2A of the directive, the court has already held that it does not constitute discrimination of that sort, provided that it covers any manifestation of such belief without distinction and treats all workers of the undertaking in the same way by requiring them in a general and undifferentiated way inter alia to dress neutrally, which precludes the wearing of such signs. Therefore, I cannot permit a Hindu child to wear, my lords, a religious symbol, but not permit a Muslim child not to wear a religious symbol. Therefore, it is not a case, my lords, because a Muslim child is wearing a hijab, there is a Hindu child telling me today that he or she will wear a saffron scarf. Where is the end to it, my lords? Both of it, my lords, this negative equality situation can't come in. My lords, with this, I go straight away, my lords, to just 2 paragraphs in page number 16, paragraph number E. My lords, I will not read. Come straight away, my lords, to page 16, essential religious practice. Please come to page 17, my lords. I have quoted in paragraph 21 of my note. I have quoted, my lords, paragraph 122 and 124 of, my lords, the opinion of Justice Deepak Mishra, who, my lords, for himself and Justice Kanvilkar in Shabarimala. May I, my lords, read that one line there and straight away go to, my lords, 2 paragraphs in Justice Nariman's opinion, and I'll stop at that. My lords, kindly see what Justice Deepak Mishra at 122 says in Shabarimala. In the light of the above authorities, it has to be determined whether the practice of exclusion of women in the age of 10 to 50 is equivalent to the doctrine of a Hindu religion, or that a practice that should be regarded as essential part of a Hindu religion, and whether the nature of Hindu religion would be altered without such exclusionary practice. My lords, I come down to the wording, my lords, which says prayers and deity, and the last 3 lines in that para. In the absence of any spiritual or textual evidence, cannot accord to the exclusionary practice followed at the Sabarimala temple the status of an essential practice of Hindu religion. My lords, please turn over leaf. Please come straight away, my lords, to the opinion, which is, my lords, the opinion of Justice Nariman at page 18, para 176.6. My lords, in that 176.6, please permit me to read, my lords, about 10 lines very quickly. It is only the essential parts of a religion as distinguished from secular activities that is the subject matter of the fundamental right. Superstitious belief which are extraneous and unnecessary accretions to the religion cannot be considered as essential parts of the religion. Matters that are essential to religious faith and or the belief are to be judged on the evidence before a court of law by what the community professing the religion itself has to say as to the essentiality of the belief. One test evolved would be to remove the particular belief stated to be an essential belief from the religion. Would the religion remain the same or would it be altered? Equally, different groups of religious communities speak with different voices on the essentiality aspects presented before court. The court is then to decide as to whether such practice is or is not essential.
इसीलिए GoDaddy प्रोफेशनल ईमेल
Religious
लीजिए ताकि
activities
बिजनेस और
may
इमेज
also be mixed up with
तो गाइस
secular
आप लोग भी ऐसा
activities, in
व्हीली
which
कर सकते
case
हैं
the
अपने बिना
dominant
गियर वाली
nature of
साइकिल
the
पे। उसके
activity
लिए
test is
वीडियो
to
को
be
पूरा
applied. I
देखिए।
stop there, man.
हे गाइस, वेलकम टू माय चैनल।
Because if we say that a child who wears a hijab is prevented to wear a hijab into school, question is, would it alter the religion or would the religion remain the same? The sequitur is this. Does this mean that all the other 95% of the Muslim children who are not wearing hijab to a school, they are not professors or practitioners of Islam? Has the essence of Islam changed by a lady wearing or not wearing hijab? Akin to Hindu faith, my lords. If I don't actually wear, my lords, a tilak, or if I don't wear, my lords, a saffron attire when I go to pray, if I go to a temple, my lords, in a denim jeans and a t-shirt to pray, is the essence of Hindu religion lost? My conscience is, I want to be a Hindu, I profess Hindu faith. But my attire, my lords, is just a manifestation. Please come to 285, my lord. Next para is of utmost importance. And my lord, this 285 is Justice Chandrachud's opinion, my lord. And I read that, my lord. It went through an editorial correction. I put that as well and I read it. My lord, 285. In this jurisprudence of religious freedom, this court has evolved a body of principles which define the freedom of religion under Article 25 and 26 to practice, quote unquote, essential to religion. The Constitution has to protect not only freedom of religious belief, but acts done in pursuance of those beliefs. While the views of religious denominations are to be taken into consideration in determining whether a practice is essential, those views are not determinative in its essentiality. Kindly note that. The court has a central role in determining what is or what is not essential to religious belief. Intrinsic to the role which the court has carved out, it has sought to distinguish between what is religious and what is secular practice, even if it is associated with religious activity. Going further, the court has inquired into whether a practice is essential to religion. Essentiality of a practice would, as the court has held, depend on whether the fundamental character of a religion would be altered if it were not observed. Above all, emphasis on constitutional legitimacy. Kindly note this, Millets. Above all, there is an emphasis on constitutional legitimacy, which underscores the need to preserve the basic constitutional values associated with the dignity of the individual. Millets, I stop there. The basic constitutional value for me as a school is I have to impart secular education in my school. I have to, my lords, under 39J, ensure that dignity of the girl child is protected. I will not, my lords, prescribe a protective attire to a girl child and no protective attire to a boy child. Why? On the religious faith, to saying that girl must dress modestly and a boy need. My lords, for a minute, please permit me to dilate on this. When religion, my lords, was formed and these embodiments came in, my lords, in our holy texts, whether it is the Quran, whether it is the Bible, or, my lords, the Hindu religious texts, that was a time when society, my lords, might have had certain requirements to maintain community standards. Maybe at that point of time, women had to wear a particular attire for maintaining community standards. That is, that you protect yourself from the gaze of a man, etc., etc. May have been, I don't know, I'm no expert on it. However, today, my lords, community standards are not maintained by our religious texts. Today, in a democratic polity that is India, community standards is maintained by the rule of law. a man actually misbehaves with a woman, he should be prosecuted under the law. When the rule of law maintains community standards in a secular democratic polity, the question then I ask myself is, what is the need to have a protective attire for a female on the basis that a female should be protected from the gaze of a man and the female must dress modestly? My lords, I again ask myself the question, why is that we teach our girl child to dress modestly and not our boy child to dress modestly? Are our girls educated than our boys? Is that what the constitution, my lords, imposes upon us to build a society? Therefore, my lords, as a school, I have the obligation to ensure that I gradually go towards a gender neutral uniform. Not even to say salwar kameez for girls and pant and shirt for boys. Certainly not to say that girls must therefore protect themselves with a headgear. In that light, I have an obligation, my lords, an argument was raised before your lordships, my lords, in the connected petition by my esteemed friend, Mr. Kamath. Once it is a matter of faith, nobody should go into it. It is the person's faith that should be protected. Your lordships also should not go into it to take a decision on whether it is essential or not essential. With utmost respect, the law is marched. My lords, after pre-Shirur Mat, my lords, whatever may have been the law, after Shirur Mat, after Venkataramana Devaru, after Saifuddin Saiba, my lords, that is the Mori Muslim excommunication case, and my lords, now Shabrimala, the law is, court is central to taking a decision that it is essential or not essential. It is not left, my lords, to the private person. And that can be done only by evidence that is being brought in court. If my learned friends had filed a civil suit, my lords, and brought in evidence, it's a different matter. No, not even a single affidavit, my lords, brought in to indicate whether it is essential or not essential, except to quote, my lords, one or two paragraphs of the Quran. Therefore, my lords, the fact that that burden is, my lords, not discharged, kindly see, my lord, the last three lines, my lords, of Justice Chandrachud's opinion at 285. Apart to, my lords, character of a religion, etc., fundamental character of religion being altered, they say, above all, constitutional legitimacy is the question. In a constitutional legitimacy situation, can we dress our girls differently to say, no, you have to dress modestly? Where is this concept of modesty for a girl child coming from when there is no school uniform of modesty for a boy child? Well, in that light, I'm conscious that I have gone beyond 3:45. Would your lordships give me 1 minute, my lords, on the justification? Please come to page 20, my lords. My lords, in page 20, please come to, my lords, page 20, para 23. Free speech consideration. I will not read it, but please, my lords, note 373 of Puttaswamy. In 373 of Puttaswamy, the question came up on, will religious appearances be a part of personal autonomy and therefore a 19(1)(a) and a 21 right as right to privacy? That was also pitched before your lordships. I have personal autonomy. I should be allowed to wear what I should. My lords, in 373, their lordships say, the choice of appearance and apparel also aspects of the right to privacy. But continue, please continue. The freedom of certain groups of subjects to determine their appearance and apparel, such as keeping of long hair and wearing a turban, in this case, Vijay, are protected not as part of a right to privacy, but as part of their religious belief. Therefore, this protection applies to them under 25(1), which is subject to 25(2). And therefore, my lords, we can by saying everything is put under 19, everything is put under 21. Freedom of conscience is also 21 minutes. How can I be a full-fledged individual and not have a right to life if I don't have a freedom of conscience? But freedom of conscience is 25. It is subject to other parts of Part 3. It is subject to 25(2), which is subject to, my lords, building an egalitarian, social, secular order in the country. And that is important. That's why I brought Bommai, saying maintaining a secular order is the paramount obligation, my lords, of the state, or for that matter, educational institution. And when it comes to education institution, I must be given the latitude, my lords, to prescribe my uniform. My lords, last thing is G, my lords, at 21. This is, my lords, the justification pattern. My lords, Regina versus Denbigh was brought in, my lords, that is the House of Lords decision. I will not read it, but I will only trouble your lordships, which are kindly see these paragraphs. The question, my lords, which Baroness Hale brings out is this. My lords, in para 96, Baroness Hale brings out. May I, my lords, would your lordships permit me in 3 minutes, my lords, read 96, 97, and I stop. My lords, kindly see what Baroness Hale says in Regina. After looking at the modicum of entire law and rights and freedom of religion. My lords, I read 96. 96 ostensibly is against it, but please see how it goes out. If a woman freely chooses to adopt a way of life for herself, it is not for others, including other women who have chosen differently, to criticize or prevent her. Yes, somebody can wear hijab, somebody can wear the shortest of clothes, no problem. Judge so-and-so in Center versus Turkey draws an analogy with the freedom of speech. The European Court of Human Rights has never accepted that interference with the right or freedom of expression is justified by the fact that the ideas expressed may offend someone. Correct. I can't say it offends me, therefore don't wear hijab. Likewise, the sight of a woman in full parda may offend some people, and especially those Western feminists who believe that it is a symbol of our oppression. But that could not be a good reason for prohibiting her from wearing it. Correctly so, it is her right to wear. But please see 97 minutes. But schools are different. Their task is to educate the young from all the many diverse families and communities in the country in accordance with the national curriculum. I have a state curriculum. This task is to help all of their pupils achieve their full potential. This includes growing up to play whatever part they choose to in society in which they are living. The school's task is to promote the ability of people of diverse races, religions, and cultures to live together in harmony. Fostering a sense of community and cohesion within the school is an important part of that. A uniform dress code can play its role in smoothing over ethnic prejudice and social divisions. But it does more than that. Like it or not, this is a society committed in principle and in law to equal freedom of men and women to choose how they will lead their lives within the law. Young girls from ethnic and cultural or religious minorities growing up here face a particularly difficult choice: how far to adopt or to distance themselves from the dominant culture. A good school will enable and support them. Stop there, Melody. A good school will support a girl child to say, I don't want to wear it. For which I have to first make sure that I instill constitutional values in them until they become a major, and then take a decision for themselves on whether they want to wear a particular attire or not. Malats, in that light, the last paragraph, Malats, I'm not reading Malats 98 and 99. I wish Malats I could have read the in para 26 as well, Malats. But kindly see para 27, Malats. In the light of the above, that allowing exceptions or exclusion to uniforms in the name of religious freedoms and non-discrimination is a self-defeating argument. Uniforms are mandated not with an intent to discriminate, but to prevent the very discrimination on the grounds of social, economic, and religious status. That's exactly what I need to do, Malak. To remove the discrimination, everybody wear the same thing. You may be rich, you may be poor. Everybody wear the same uniform. You may be Hindu, Muslim, wear the same uniform. In that light, I will end my lords by introducing my lords para 54 of Shaira Banu. My lords, Shaira Banu is there in the Aegis compilation. In Shaira Banu, my lords, their lordships, my lord, when looking at whether this is actually a mandate in the Quran, etc., clearly, my lords, in 54 indicate there are multiple degrees of compliances that Quran indicates. Starting, my lords, from the fard, which is the first degree, to my lords, haram, which is the fifth degree. They say we can't be sitting down and saying that everything in the Quran is therefore essential religious practice. And if somebody wants to prove it, my lords, that evidence must be brought. But my submission, my lords, is one step more, and therefore I'm pitching it differently. Even assuming it is an essential religious practice, under Article 25(2), I am entitled as a school to ensure that no religious compound. And it shall not, my lords, until my school runs as a secular institution, imparting public instructions, that to my lords with the aid and of the state. I am obligated, not just I have a higher order, I am obligated under the Constitution to ensure that no religious symbol enters my school compound. My lords, with that, my lords, I rest my case. I am very, very grateful for the patient hearing.
Thank you. Continue tomorrow. Represent whom? Who is respondent number 8?
Yaru. Respond number 8. Who?
Who is respondent number 8?
Describe teacher, student, college. Huh?
What more is to be argued on behalf of the teachers, Mr. Mr. Pawar?